Okay, thank you. Well, good afternoon, everybody. Thank you very much for joining this webinar, the title of which is Protecting Survivors of Conflict-Related Sexual Violence. What role should CEDAW play in its 40th year? And we are hosted today by the Royal Norwegian Embassy in Juba, as well as Legal Action Worldwide and Allen and Overy. And I'll introduce myself. I'm a partner at Allen and Overy. I'm an international arbitration partner and co-head of the gender part, as well as the business and human rights practice, where we have been focusing on some of the issues that we'll be dealing with today. The concept of this panel is really in part to celebrate the 40th anniversary, which was held last year, of the Convention on the Elimination of All Forms of Discrimination Against Women, as well as the optional protocol to that convention, which established a complaint and inquiry mechanism for the convention, and that's in its 20th year. And my muddling up whether I'm doing gender-related work at my current law firm is attributable to the fact that 20 years ago, I was actually doing something called the Gender and Human Rights Program at the Inter-American Institute of Human Rights. And at that time, we were facilitating the negotiation of the optional protocol. And I had the great pleasure to meet one of our speakers then, who I will introduce. So it is something to be commemorated that we are in the 40th year of the convention and the 20th year of the optional protocol. Regrettably, as the audience will know, we are also still in a situation where protracted wars around the world have continued to have a devastating impact on women and girls. Indeed, in 2020, the Special Representative of the UN Secretary General on Sexual Violence and Conflict found that 19 countries currently are affected by the threat, occurrence, or serious legacy of conflict-related sexual violence. And there are 54 different state and non-state actor groups involved in this kind of gender-related conflict-based violence. Now, this is often conflict-related sexual violence is often part of the strategy of parties to a conflict. It is often used as a tactic of war or terrorism against the population, and survivors' ability to access justice today continues to be hindered by numerous barriers, including lack of confidence in judicial systems, fear of reprisals, and stigma. The need to combat impunity continues. And indeed, despite global resolve to combat impunity, it remains pervasive. Now, the object and purpose of CEDAW, as well as its optional protocol, is the elimination of all forms and manifestations of discrimination against women and girls, and conflict-related sexual violence is a pervasive form of this gender-based discrimination. And there are several impediments to women accessing CEDAW, just as there are to accessing justice at the domestic level. One of the key impediments to accessing CEDAW is the threat of retaliation and reprisals. Remember that very often the perpetrators of sexual and gender-based violence during armed conflict are state actors themselves, and therefore women who speak out against their state are often in a very vulnerable position. And it is the argument of law and Allen and Overy in a recent petition to CEDAW that we submitted this morning that the CEDAW committee actually has the discretion to protect the identities of women and girls when they file a communication within the optional protocol. And we submitted a petition this morning for 30 women and girls who were the victims of sexual and gender-based violence during the armed conflict in South Sudan. And along with that communication, we submitted a request for identity protection, arguing that the committee indeed has the discretion to protect the identity of these victims. So Antonia later, when we get to that stage of the presentation, will talk a bit about this petition and call upon the committee to accept it. Now, today's panel is intended to discuss some of the issues that will be raised in the context of how can women and girls be protected, how can they be protected from reprisals, while also being able to access justice and obtain redress for conflict-related crimes. And we'll talk about CEDAW as well as the optional protocol and then other mechanisms that could assist in obtaining redress at the international and domestic level. We are extremely pleased and honored to have here with us for opening remarks Ambassador Siv Kaspersen, who is with the Royal Norwegian Embassy in Juba, and I'll give the floor to her in just a moment. And then we will have Jane Connors, who currently is the victim rights advocate for the United Nations, but also at the time of the drafting of the optional protocol, I remember Jane very well as the chief of the Women's Rights section in the Division for the Advancement of Women. And she supported the open-ended working group of the Commission on the Status of Women during the period of the drafting of the optional protocol. And was very involved in those proceedings. We're also honored to have with us Madeleine Rees, who is the Secretary General of the Women's International League for Peace and Freedom, and she's also the former head of the Office of the High Commissioner for Human Rights and was their gender expert in Bosnia and Herzegovina and the former head of the Women's Rights and Gender Unit at the office. Finally, we have Antonia Mulvey, who is the Executive Director of Legal Action Worldwide and is doing wonderful work around the world, bringing legal cases on behalf of women and children, particularly in the context of armed conflict. And as I mentioned today, has filed a potentially landmark petition and request for identity protection just this morning for the CEDAW committee. So please, without further ado, if we could hear from the ambassador some opening remarks.
Yes, good morning or good afternoon. Here in Juba, it's afternoon. It's 5 o'clock. Thank you for inviting me to give my opening remarks. I feel humble to be with you in this panel. I am not the expert myself, so I'm very keen to listen to you later on. I think this conversation comes at a very timely point, particularly in the context of South Sudan, where the people and the government are in the process of implementing the peace agreement from 2018. But where we still receive reports of conflict-related sexual violence. In fact, several parties in the armed conflict use sexual violence as a weapon of warfare. Today's armed conflicts increasingly expose civilians to extreme violence committed by non-state armed groups as well as state armed groups. Civilians are caught on the front lines of conflicts around the world, and one of the most devastating forms of hostilities waged against civilians is sexual violence. And sexual violence is not a side effect of war, it is frequently used as a weapon of war, and too often met with impunity for perpetrators while silencing survivors. So sexual violence is a weapon that aims to destroy not just the victim, but entire families and communities, the very social fabric as we see it for generations. It erodes the society we are striving to stabilize and rebuild. And conflict-related sexual violence is a violation of international human rights and international humanitarian law. It can be a war crime, a crime against humanity, an act of genocide. So to focus on South Sudan, South Sudan ratified the convention, CEDAW convention in September 2014, just after the brutal civil war started in December 2013. And sexual violence has been used and continues to be used as a weapon of war in this country. And we know that there has been a significant decrease since the signing of the peace deal in 2018. However, it remains a serious problem, with victims continuing to suffer appalling acts of sexual violence that often result in long-term physical harm and mental health consequences. Early this year, the UN mission in South Sudan, UNMISS, and the UN Human Rights Office of the High Commissioner released a report on access to health for survivors of conflict-related sexual violence in South Sudan. The findings of this report were upsetting. The report documents 356 incidents of conflict-related sexual violence, including rape, that took place between January 2018 up to January this year, with the majority of the incidents taking place back in 2018. The incidents involved at least 1,423 victims, including 302 children. And those responsible for the violence included government and opposition forces, as well as youth militia used by the parties to the conflict. And these are just the incidents being documented. The unrecorded incidents might, well, they are absolutely higher. And I visited a one-stop center last week, which we are financing through UNFPI, and majority of the survivors were young girls. But what we see regarding numbers is really just the tip of the iceberg. There are so many not reporting these acts of crime. As mentioned, we know that sexual violence has been used as a weapon of war to tear apart the social fabrics of families and communities, to displace civilians, and to inflict individual and collective trauma. Gender-based discrimination and the continued lack of criminal accountability has fueled violence, contributing to its normalization in society and further sustaining gender inequality. The parties to the conflict in South Sudan did endorse an action plan committing to take measures to prevent and respond to conflict-related sexual violence. And we have seen some measures being taken in South Sudan. I took place in the opening of the 60 days of activism today, and one, if to say something on the more positive side, is that the government now, they have a new bill of to work against sexual gender-based violence. So let's see how that process will move forward. It's not an easy one, but at least it is a start. Early this year, a legal committee and district court martial was set up by the SSPDF, that is South Sudan People's Defense Force, in Yei area, in the southern part of central Equatoria, not far away from Juba, to prosecute soldiers and security personnel suspected of having committed crimes against citizens of Yei, including sexual violence. As a result, in fact, 26 soldiers were convicted for offenses against civilians and violations of the SSPDF military code of conduct. The soldiers found guilty of rape or sexual assault were sentenced to a period ranging from 6 to 14 years in prison and dismissal from the forces, SSPDF forces. Of course, this is a single case and not a sustainable nor preferred solution to providing victims with access to justice. The peace agreement from 2018 provides for the establishment of a hybrid court together with the AU. And it's my understanding that the AU has submitted the necessary documents, including the MOU that would enable the hybrid court to be established, but the South Sudanese leadership has not done its part yet. And Norway and others in the international community are advocating for full implementation of the peace agreement. And we want the government of South Sudan to fast track the establishment of the hybrid court and other complementary transitional justice mechanisms to deal with human rights violations, including women's rights violations. The government has the greatest responsibility, of course, for addressing violence against women and girls. In our view, the hybrid court is the clearest path forward to provide accountability for the violence women experienced during the conflict and still continues to do. But there's no real sign yet on when that hybrid court is going to be established. In the concept note for this event, it says combating impunity for sexual violence is a central aspect of deterring and preventing such crimes. It is also a central element of providing redress for victims. And I could not agree more. We believe that ensuring access to justice for victims of conflict-related sexual violence is indeed essential for the victims. But we also believe that ensuring access to justice and holding perpetrators accountable is crucial to the continued peace and stability of the country as a whole. Continued abuses will only fuel more conflict and tear societies apart. I'm honored to open the discussion on conflict-related sexual violence and what the UN mechanisms can do to support victims. As I said, I'm not the expert myself, but this is a topic of great concern to me in the context where I'm operating. And I'm very keen on hearing the reflections from all of you. Let me perhaps end by emphasizing that preventing and responding to conflict-related sexual violence will continue to be a priority for Norway. Early this year, we welcomed the first policy for United Nations field missions on preventing and responding to conflict-related sexual violence. It affirms that a survivor-centered approach is required to address conflict-related sexual violence in all United Nations peacemaking and peacekeeping and peace-building initiatives. The policy provides clear guidance for field personnel deployed to United Nations field missions to support the fight to eradicate this crime. And I'm happy that we have supported the UN Department of Peace Operations in collaborations with other partners in developing the first whole of mission handbook for UN field missions on preventing and responding to conflict-related sexual violence. We also think that having specialized police teams to support national police capacity response to sexual violence is a very practical step. And in Juba, we have a joint Finnish-Norwegian police team under the leadership of Finland. And we think that is a very practical and good approach actually to train national police. And it's very happy to continue with that sort of support. And as Norway will join the UN Security Council from January next year, I can promise and assure you that women, peace and security and working on this topic, gender-based violence and sexual gender-based violence will definitely be a priority for Norway. So thank you so much for your attention.
Thank you very much, Ambassador. We're very grateful to you. If we could please now have Madeleine Rees. Or are we going to, forgive me, Jane Connors, I think, is up next. I'm sorry about that. Jane, if you would like to take the floor.
Thank you, Suzanne, and thank you also, Ambassador Kaspersen, for your very interesting introductory remarks. I have a lot to do with South Sudan in my mandate, and I visited in late 2017 and plan to do so next year to see how things are going with sexual exploitation and abuse. I'm really pleased to be here. I'm really pleased to be here with Antonia and also Madeleine. You've spoken about how timely it is, the 40th year of CEDAW, almost the 20th anniversary of the entry into force of the optional protocol. But importantly today, it is the International Day for the Elimination of Violence Against Women, the beginning of the 16 days of activism. As you know, this day commemorates the assassination of the Mirabal sisters in the Dominican Republic in 1960. So it's a very important day, and the 16 days of activism end on Human Rights Day on the 10th of December. I'm hopeful that during these days of activism we can focus, in addition to all forms of discrimination and all forms of violence against women, how COVID has escalated the incidents in many contexts. I was asked to reflect a little bit about Article 6 of the optional protocol. And the optional protocol, I'm always happy to say, and Suzanne and I worked together, it was achieved in record time. People told me that it wouldn't be achieved. I had a bit of competition because there was an optional protocol on the Convention on the Covenant on Economic, Social and Cultural Rights, also under negotiation, but that inspired me. I thought that we could beat that, and we certainly did by many years. You've heard of the competencies, the communications competency and the confidential inquiry competency. With regard to Article 6.1, and this is the issue which Antonia will pick up, it provides that unless the committee considers a communication inadmissible without reference to the state party concerned, and provided that the individual or individuals who are the complainants consent to the disclosure of their identity to that state party, the committee shall bring any communication submitted to it under the protocol confidentially to the attention of the state party concerned. So essentially that article provides that everything should go, if there isn't, on its face, an anonymous communication or a flawed communication in another way, as long as the individual consents, provided that the individual consents, the committee shall bring the communication to the attention of the state party concerned in order to get its views. And that provision is consistent with other human rights treaty communications procedures, but it provides more protection to complainants by requiring that they consent to the disclosure of their identity before the transmissal to the state party. Difficult words, law. I have a silly little secret. Before I joined the UN, I was an academic, and in fact, with a very well-known professor, Andrew Burns in Australia, we in fact drafted an optional protocol. We provided an academic draft, and we learned that there was a difference between theory and practice when it came to negotiations in the open-ended working group. And we had put forward a provision in our academic draft which would have protected the identity of, which would have allowed the committee to take up a communication without the identity of the communicant being transmitted to the state party. And that, of course, was the draft that went to the working group was negotiated, not our draft, but another draft. And this issue of whether there should be a capacity to protect the identity of a communication which isn't anonymous, and that's very, very important. The communication isn't anonymous. The committee knows who the communicants are, but could their identity be protected in exceptional cases where, for example, their health or life would be in danger. This was a position which was advocated by the committee at the time, and during negotiations there was a resource person from the committee who underlined, on the basis of the committee's experience, the situations of vulnerability that many complainants are in, and it's very obvious in South Sudan, and also the very specific risks to women and girls. And South Sudan has some interesting customary legal practices It also criminalises all aspects of transactional sex. So you could imagine that there are risks if women's identities are known when they submit after they submit their communication. Many states during negotiations were sympathetic to the need for safeguards for complainants, but they did consider that the state party would need to know the author's identity in order to investigate the allegations, remedy the situation, and provide full information to the committee so it could make some decision on admissibility and indeed merits. Some states suggested protection concerns could be met by allowing the committee to temporarily withhold the victim's identity throughout or during consideration of interim measures requests. Lots of discussion, but the practical, I think, prevailed, leading to the current formulation, which envisages the consent requirement of the complainant and the confidentiality requirement that the transmission to the state party be confidential as providing sufficient protection. The last word on this came through the interpretive declaration of the UK and Sweden on the adoption of the optional protocol in the Commission on the Status of Women. There was a set of interpretive declarations, and they stated that their understanding was that in cases where the author refused to consent to disclosure of their identity, the committee may not consider the communication, although information received in this context could be considered if relevant to its other functions, which is quite interesting. These might include reporting, inquiries, or follow-up to these procedures. And I think they didn't say that, that's what I think. These would include reporting, inquiries, or follow-up to these proceedings. Now, it's interesting, if you look at the most recent inquiry report of the committee, which relates to female genital mutilation in Mali, you will see that two of the organisations submitting information which generated that inquiry are clearly required that their identities be kept confidential and their identities are not revealed. So if the committee can do that there, it does have a bit of a challenge in terms of what is the clear reading of the optional protocol. But I'm sure Allen and Overy and Antonia have come up with very good arguments with regard to how things can be read differently. And it is interesting to know that there is a clear confidentiality requirement with regard to inquiry reports, which the committee has managed to get around. For completeness, it's important to note that communications where the author does not consent, as I say, are not anonymous. So that often is a confusion. People say they're anonymous complaints. They are not anonymous complaints. They are just complaints where the complainant would like protection of their identity for various, usually very good reasons. Bear in mind also, this is the first complaints procedure which includes a provision whereby the state party, and that would be South Sudan, undertakes to take all appropriate steps to ensure that individuals under its jurisdiction are not subjected to ill treatment or intimidation as a consequence of communicating with the committee under the protocol. This did generate some restrictive interpretive declarations, but it's a very strong provision, and I have to say it was inspired by work that Norway had done with regard to human rights defenders, the Declaration on Human Rights Defenders. It's also interesting that the committee has adopted the San Jose guidelines against intimidation or reprisals of those who seek to communicate or work with human rights treaty bodies, and it has implemented a process to address such acts. But I think it could go a bit further. It could develop these procedures, particularly, and I've had I looked at its general recommendations, which are relevant to this topic, those on access to justice, on conflict prevention and so on, violence against women, and they do not address communicating with the committee itself. They address risks in terms of access to justice that the state might provide, but they don't go a little bit further and talk about the risks that the individual might face. Just to complete what I'm, more or less what I wanted to say, I think we have to, this issue raises for me a fundamental question, and that is, what is the objective of the mechanism? I mean, what is the objective of the optional protocol? What is the objective of other human rights procedures? With human rights treaty bodies, usually they become seized of issues well after the fact. And they certainly provide a framework for individual relief, the realisation of which is dependent on the willingness of the state's parties to implement their views and recommendations. Their greatest strength for me is providing targeted guidance to states parties on how they must act to meet the obligations in treaties which they have freely accepted. And a very good example of this is CEDAW's recent decision in SH and Bosnia and Herzegovina, where the committee found violations of the author's rights on various contexts, in the context of conflict-related sexual violence, and made recommendations, not many relating to her situation, about 3 relating to remedies, compensation, etc., but many recommendations and very detailed and specific recommendations of a general nature. So I think we have to reflect when we're thinking about procedures, what is their objective? We might have a bit of opportunity in the question and answer. I don't want to take up any more time to talk a bit about my mandate, which is very specific and where protection concerns are a real issue. Addressing sexual exploitation and abuse by United Nations personnel raises issues of confidentiality, consent and protection concerns. And there are many reasons why people don't report, including risk to life, risk to health, reprisals, inducements, and so on and so forth. So I'll stop at that point, and hopefully that's been a little bit illustrative of the issues that we have in front of us. But thank you again to the Ambassador, and I hope that we will meet in South Sudan if I can manage to go there next year. I'm sure I will be able to do so. It is doing quite well in its work on sexual exploitation and abuse because I have a senior victims' rights officer implanted in the mission there who has a system-wide role, and I hope the Ambassador is in touch with her. Thank you so much, Suzanne, and also to everybody else. I look forward to the rest of the discussion.
Thank you, Jane. And yes, I'm sure there are a number of things we can talk about later in the Q&A. Antonia, the floor is yours.
Thank you so much, and good morning, good afternoon, good evening, and thank you so much for everybody for joining us, and in particular, our esteemed panel, Jane, Madeleine, the Ambassador, and of course our chair, Suzanne. It's fantastic to be here. Now, for any of you that don't know Legal Action Worldwide, I'm just going to say a few words about us before I go to the issue at hand. Legal Action Worldwide is a non-profit organisation of human rights lawyers and jurists who work in fragile conflict-affected areas. We're providing creative legal solutions, legal assistance, and direct representation, often through strategic litigation. And we look very much at what kind of justice do the individuals and communities want, and how can we help them to achieve that? We also work with governments and justice institutions to help them uphold the human rights and the rule of law, and also on advocacy. Now, I'm going to turn to the issue of today's topic. And I just want to sort of go back a few years, and I was thinking, how do we come to today to be filing this communication this morning? And yay, congratulations to all the team, and I'm going to talk about that because it's been a huge piece of work. Law started working in South Sudan about more than 5 years ago. And I think for all of you who've joined us, everyone is well aware of the shocking levels of sexual violence in South Sudan, which have continued despite peace agreements. Sexual violence is taking place on both sides, both from the opposition and from the government, armed men in uniform, and the military. And around more than 3 years ago, we met with some of the survivors of this sexual violence, women and girls who had fled South Sudan and into the neighbouring refugee country where they're residing in the camps. And I must say, their stories are shocking. And I just want to share with you some of the testimonies that we have taken so we can also understand, I think, the importance of them seeking justice. The youngest of those that we're representing is 12. She was gang raped with her sisters in the kitchen with a family friend, and it's alleged against the South Sudan military. There is the 42-year-old woman that we're representing, the oldest of the complainants. She was in a military camp. Again, allegations against the South Sudan government military. One of the officers blew a whistle so that the next soldier would start raping. And so she was gang raped and exchanged on the blow of a whistle. We have a mother who was gang raped by 4 men, again in military uniform, in front of her children. She managed to escape, and on fleeing, she was again gang raped in front of her children and miraculously managed to cross the border. It is in that framework that we are bringing forward this case and looking to see where can we provide justice to these survivors. And I don't think everybody is a survivor. Some people, don't manage to move forward from these things, and how can you? But I'm going to call them survivors. And if we look at the situation in South Sudan, and we heard it set out very well by the panelists and the ambassador, it is a situation where, yes, attempts have been made to have justice for the survivors and for the victims. But let's be clear, there is massive impunity for crimes that have occurred during the conflict, and in particular for sexual violence. When we looked at to see whether there have been court-martials, we could only find one, the very well-known Terrain case, and if you speak to the survivors of that Terrain case of 2016, well, you'll be aware that a number of international aid workers were raped and submitted to sexual violence. They have not all been not all agreed with the proceedings that have taken place. And then there has been one court-martial which has resulted in 9 convictions of military. That's since 2012 that we could find. So we're talking about almost total impunity. Those that we represent have a real fear of the government security forces. They fear retaliation, and they have a right to do so because there is a history of retaliation and cross-border. They fear stigma from within their community. And it's on that basis that they want to have their identities protected. So we have filed a communication this morning again, because we had previously tried to attempt to do this. And again, a great shout out to the team for this huge piece of work. We have argued that South Sudan has breached numerous articles of the CEDAW Convention. We have also made a request for the protection of identities of those that we are representing. Now, we heard very well set out by Jane earlier that protecting our identities is not the same as an anonymous communication. And if we look at CEDAW, we have Article 6.1 under the optional protocol, which states that a communication cannot be anonymous. We are arguing it is not an anonymous communication. We have provided identifying information of our clients, And we have particular concerns, of course, of those who are children, and there are a number of them, and they do not consent to having their identities released. And we're arguing that the CEDAW committee can interpret it as such, that the protection of their identities can be allowed where they haven't consented to reveal them. And also we're arguing that it's really not in the spirit of CEDAW, particularly in its 40th year, not to protect the identities of these women and girls, which effectively would now allow them not to make communications before CEDAW, and not to, in their words, to allow the enjoyment by women of all their human rights. And we believe this is supported by General Recommendation 19 and 28 of CEDAW, where they have specifically placed the importance of addressing sexual and gender-based violence by the committee. So here now I make a real call upon the committee to consider our communication. They haven't done so previously, and we really hope that they will take it very, very seriously, the communication and the request for protection of identity. Just want to make a couple of other points. I think, let's look at the situation of when CEDAW several decades ago was being drafted and the situation now. What is the jurisprudence? I think that's also supporting our argument. Well, let's look at it. We have the International Criminal Court case of Ongwen, and I'm going to read out, if you allow me, which stated in the decision, the participation of anonymous victims in the trial proceedings in and of itself does not violate the accused rights to a fair and impartial trial. That's the International Criminal Court. And of course there is preference for the disclosure of the victim's identity, does not preclude a fair trial. And we often hear that the state is saying, we need their full identities to investigate. We would argue, no, you don't. Just also in the case of Tadic on the ICTY, I apologise for my pronunciations, it also held that the identities of the victims and the witnesses could be withheld from the accused and from the counsel of the defence. We also have, of course, the African Charter, which allows authors to request anonymity. We also have examples from domestic proceedings, including recent cases in Guatemala, where the protection of women and girls who are subjected to sexual violence, including sexual slavery, were withheld during their proceedings. And I think that this gives us very good basis for our request. And also we have to say, where do these women and girls go for justice if it's not to CEDAW at this time? And there I will stop, Suzanne, and thank you very much.
Thank you very much, Antonia. Now, Madeleine, last but not least, are you still with us? I saw you go away, but I think...
No, I didn't go away. I think I just...
There you are. Excellent. Thank you.
No, thank you. This is really fascinating. It's lovely to hear so much law in a webinar. You don't normally have that, and lovely to hear. Obviously, Jane, you're such an expert on this, and I love the response from Antonia. What I would like to do, I was asked if I'd step back a little bit and maybe put a little bit of context on it. I think what Jane, what you said about the difference between theory and practice is of fundamental importance. And I also think what Antonia just said about the massive impunity that I think we have seen from every single conflict where there has been sexual violence and indeed other violations of IHL and of human rights. What I want to do is, I think, is to look at the reality of people's lives in the context of law, which we said should be a progressive interpretation. And I think if we rely on the teleological approach, which basically means that we have to look at what progress there has been in terms of our understanding, our social understanding, and in terms of legal process. And I say that so that we can have a look at the context in which sexual violence takes place, because that has changed dramatically. Our understanding of that, I would argue, has changed quite dramatically since the Bosnia conflict in particular, and in particular since the interrogation, if you like, of the issues under both the Security Council resolutions on women, peace and security, but also under international hard law courts like the ICTY and the ICC. From what I've seen in the experience I've had in working in various different conflict-affected countries, it's very much an issue of the context being both social, cultural, and economic, the process of law and the law itself, and then how you can access it and how you are treated in that, and both then the consequences of seeking that access to justice and whether or not it has accurately described the experiences you had and provided that redress that you've been seeking. You can't do that if you can't get to actually file your complaints. You can't do that if you're not heard. So how do you actually do that? And one of the things I think it was experience we had in Bosnia. I went first in 1996, and I went to work with, at least to give some legal advice to the organization Medica Zenica, as was then, because they were an amazing organization providing support for survivors of sexual violence. And essentially what was happening was that there were women who wanted to testify, but not many. Many women wanting to tell their story, but then not making that leap into, well, why and how would we want that to go forward to the ICTY? And investigators from the ICTY were very sort of, what do we do about this? And it didn't take that long for us to work out that, in fact, most women who were in those situations, even though they weren't articulated, were really far more concerned with looking for missing partners, looking to find out how they were going to look after their children, where they were going to live, basically looking at the whole range of social economic rights that they were denied at the ending of the conflict, and to engage in that, to be able to then seek justice for the individual harm, as they saw it, that had happened to them. So the obstacles they were facing were actually fundamentally based in issues that CEDAW addresses. Because we wanted to provide the CEDAW committee with all of its of the rationale behind it, to try and change the context in which gender discrimination takes place and provide the protection of the rights of women, hit on those very areas that were so pertinent to being able to access justice. One of the things that we found was a way forward, both in terms of law and in practice, was to provide with the provision of health rights, to be able to give assistance and support to women who were accessing those health rights, again through an NGO, so not the state, to be able to then have different legal advice. So that essentially, if you want to know what is going to happen to you, you want to know whether you're going to be safe in going through a process. You want to know if your confidentiality is going to be respected. You want to know what's going to happen to you in the courtroom. How is that going to be conducted? And then the other part is, if you don't want that, then what are your other legal remedies? How could you take forward your claims for under transitional justice mechanisms? And then if you don't want any of that, how do you still go forward and try to find access to those things which I said were so fundamental in terms of accessing healthcare and employment and welfare and documentation and knowledge of where your partners may be? So those were the three categories that were being described by women as what they wanted to know and do. And the idea was with having a one-stop shop, that information could be given. So what you're trying to do is you're trying to create a context in which information, documentation is collated, and that some women will go forward and some women will not. But what you've done is very much as happened in the Kvochka case, is you have established a documentation web, if you like, which then provides a block, a platform, for women then to or for the adjudicating authorities, in this case ICTY, to be able to state that there was sufficient evidence for those individual women's testimony to be unnecessary to be interrogated. Now, I think that's really important, because what we're talking about here in the context of CEDAW is an access to justice point. We've seen from the ICTY cases, there was this attempt at, what I've said about the Kvochka case, very important, but when women did go forward and testify, we had all the confidentiality, we had all the witness disguising, the voices and that sort of thing, but it didn't actually work, because what actually happened in the court and the interrogations that went on in the court did undermine the integrity of many of those witnesses because of this issue of corroborative action and or corroborative testimony. and in certain cases that of consent. So that's one element which, of course, we are assuming would not be present in any of the CEDAW communications. But at the same time, what we are seeing is the necessity of not just that protection being real and effective, practical and effective, but also being articulated in such a way that the woman knows that she is safe so that she can access justice. And I think in this context, it's very important for us to bear in mind the influence of the Security Council resolutions, because normally, and up until this date, it's been very much the CEDAW committee and the general recommendations which have influenced the drawing up of the Security Council resolutions on women, peace and security. I would say in this case, let us look at 2467 and what that had to say about access to justice and the way in which the criminal justice system in particular must be articulated so that it provides for a real difference in treatment of the way that testimony is given. So I'm going to stop there because I think there's so much more that could be said on all of this, but I think basically what we're looking at is for the CEDAW committee to enable the process to give the support that has been given through all the interpretations of the CEDAW Convention up to date in terms of the context in which these offences take place, a better understanding of how patriarchy works in terms of the way legal interpretation works, and so that when you have women able to come forward and provide information to the committee, it can be done in such a way that there is no prejudice to them being able to come forward and seek justice in a way which really works. And just to say, I've seen how important the CEDAW committee is to women when they have come forward. And I think the case of Syria, when they came forward at the second report they gave during the conflict, it was wonderful for them to actually stand in front of the committee and see how various members of the committee interrogated their state, because they felt that they had been a complete vindication of everything they had been saying. And I think that is something which we cannot underestimate in terms of seeking justice for particularly survivors of sexual violence. So I'll stop there and wait for any questions. Thank you.
Terrific. Thank you very much to all of our speakers. I'm going to ask the audience if you could please send any questions that you may have through the chat function on your dashboard. And in the meantime, I'll use the chair's prerogative to ask a few questions while I wait for some to come in from the audience. I believe we have lost our ambassador. Is she still with us? I think she had to go early, so I regret that we have lost her. Oh.
I'm still here.
Ah.
Just my connection is not particularly good, but I can still listen to you.
Fantastic. Well, I did have a question for you, if you don't mind. We were hoping we could hear a little bit your thoughts on what would be really the reasons that it's particularly difficult for women and girls to access justice in the context of South Sudan. And of course, in support, I would say, of our argument that these are quite exceptional circumstances for which it would be reasonable to request identity protection. But I wondered if you could shed any light on the situation on the ground in terms of ability to access justice, both domestically, and then perhaps the threats that would potentially, women would potentially face if they sought to bring complaints at the international level.
Yes, thank you for asking me that question. Of course, I'm not the expert. I mean, you are definitely more into this than I am. But I have been around and engaged in this. So I think, of course, I mean, the access to justice is not easy. It's really lack of access. And you know, the formal justice system has very limited reach and lack human resources, financial resources, physical capacity to deliver justice. And I also think the fact that people not really trusting the formal justice system is one sort of key factor. I think another important one is the stigmatization of victims. the cultural norms, perceived shame around reporting gender-based violence, and South Sudan being a patriarchal society, you know, this is the issue of the stigma is really important to understand. The good thing now is that there is a lot more talk, at least in Juba, and through radios and on the issue on sexual gender-based violence. So I think that is at least a good thing, but it's still very much a lack of awareness of the rights, what kind of support and service the survivors can get and receive, and there is a lack of safe places for protection if so needed. So I think all these issues, the stigmatization, the lack of really formal justice system, and lack of information and awareness, I think those three factors are perhaps the most important one as I can see it. Thank you.
Thank you. Can I ask one follow-up question in terms of the current sense of security on the ground there? I understand there was a peace agreement earlier in the year. What is the actual, how does it feel to be there? And do you think that there is a valid sense of insecurity or fear by people who have previously fled South Sudan?
Yes, you know, being here in Juba, you don't really feel, I mean, that kind of insecurity that most of the people actually is feeling, because here is relatively stable, but I mean, the level of violence has raised. I mean, even due to floods and floods, I mean, during the past 6 months, actually, the numbers of death and people abducted has increased. You know, so I mean, people's actually they fear or they are running for life still. You know, they have to run away because of insecurity, and also the fact that the security arrangements, which is an important part of the peace agreement, and the process of unification of the forces, it's not going on. It has stalled, and even soldiers being cantoned and being deployed to training sites, they have actually left because of hunger, because of lack of logistics. And so, and all that, and together with a very dire economic situation, the flooding, the pandemic, and all that has made the situation very difficult for, I would say, most of the people of South Sudan, and particularly the most vulnerable and women and girls. So it's not an easy situation, and so actually the level of violence is very much there in not only pockets in the country, but in many parts of the country. Thank you.
Thank you very much. I'm actually going to ask you one more. I'm keen to ask you questions now, Ambassador, because I understand you need to leave us early. So if I could possibly present one more from the floor, which has come in to me. Now, actually, let me ask, is Lillian, who is the president of the South Sudan Women's Empowerment Network, able to speak rather than me relaying it? Let me just see if I can find Lillian and unmute you. Are you happy to speak? Let's find out. I think I've unmuted you, Lillian. I've tried in any event.
Thank you for having me. My question is that asking regarding to the Tehran victims. So the question is, do you think they have received justice is just because of the international community pressure on the government? And I know South Sudan ratified CEDAW, and I'm just wondering, what does that mean to the victims in South Sudan? and whether you think everything that has been said today is absolutely fantastic and beautiful, but do you think that under this regime, whether the victims of the sexual gender-based violence will actually receive justice?
So that was the question to me, a very difficult one. Of course, I hope that by raising the issue from the international community, from a very active civil society, and also to approach some key stakeholders in the government, that we can build some sort of a critical mass to be able to move a little bit on this agenda. But again, it's not very easy, as conflict is still here, and so long as we don't have peace in the country, this will be still very much a challenge, unfortunately. But we are hopeful, and as I said initially, the fact that the Ministry of Gender has drafted a bill on gender-based violence, I think that is a good step, and we have to do everything in order to push that forward. But let's hope.
Thanks very much, Ambassador, for tackling difficult questions. We appreciate it. I wanted to turn to Jane now, and I have one small comment on the, as you might expect, on the interpretation of Article 6 of the optional protocol. One fortunate thing we recognized when looking more carefully at the negotiating history of the optional protocol is that the so-called interpretive statement by the UK and Sweden is actually part of the TREVO, part of the preparatory works, as opposed to an official declaration subsequent to their signing, or a reservation or understanding during the time of their signing. And so the government has acknowledged that, in fact, that statement has no more significance than those governments' interpretation of that provision at the time. And one can envision there was a, shall we say, a divergence between those who were potential state parties concerned about receiving communications as recipient governments, which indeed the UK government has in subsequent years. And clearly those governments, perhaps anticipating that, were not keen to receive communications without the names of the complainants. But there was another camp of people who were very concerned about the victims' well-being. And our argument, to preface it in our submission, was that debate was not resolved, and that the debate was left to the committee to decide in specific circumstances and on a case-by-case basis if there might be grounds for protecting witness identities in specific circumstances. So that's where we hope the committee will come out, that they have the discretion. So, but I wanted to point that out. But I also wanted to ask you if you could talk about the current position that you have and your current mandate, and perhaps illuminate how the current status of victim protection is. And you have a very heavy mandate and a very important role, and we would love to hear your thoughts on how that is functioning right now.
Thank you so much, and thank you for delineating how the argument will go forward. I think it would be really useful to pick up on Madeleine's point that we've had 40 years. We had progressive evolution. And what might have been the thoughts of those in the 90s, late 90s, may not be the thoughts of those now, as they have a little bit more understanding of the of the challenges that that victims face, and just be aware with regard to if they face challenges in proceedings under the optional protocol where they are not required to appear before the committee, it's not like a domestic legal system, then they really face real challenges. So I think it would be useful. I don't find the interpretive declaration, it's the only part of the Travo. There was no Travo except for those declarations. I don't find them that statement that negative, because of the rider, that it could be used for other purposes. And so now you might be able to say, well, as things have gone on, we see that not only other purposes, but also we can think that there would be some sort of appreciation of the real situation that women find themselves in. My mandate is, just very quickly, I could go on for hours and you wouldn't like that. My mandate is very specific. It was created by the Secretary General himself. It's not created by states. However, states have allowed it to go forward, so it's now funded through the regular budget, so that is a pretty big deal. It is to support victims of sexual exploitation and abuse by United Nations personnel. And United Nations personnel, be they uniformed, be they civilian, be they national or international, and also our partners. And it isn't confined to peacekeeping, which is very, very important. It also touches on exploitation and or abuse by humanitarians and by development UN personnel. And you may have seen the articles in the New Humanitarian relating to the sexual exploitation and abuse in Eastern Congo in the Ebola response. So it's clear that this is a big issue, though I have to say most United Nations staff and related personnel perform their duties with integrity and they do not engage in sexual exploitation and abuse. The biggest challenge I think we face is getting people to come forward, and I really appreciated I'm using the word survivor, but they may not be survivors, they're victims. I mean, they've got a long way to go, and when I hear the I suppose the discussions on why is your title victims' rights advocate rather than survivors' rights advocate, because I say, you know, one really big precondition of being a survivor is that you might have to be alive. But I can think of other issues that I could raise. But getting people to come forward to report on such wrongs, and bear in mind the UN has only got administrative and disciplinary sanctions that it can deliver with regard to those people, is an enormous challenge. And it's a challenge, as Madeleine picked up, and also the ambassador, because of many reasons. There are real protection concerns. Just as I said, in South Sudan, for example, all elements related to transactional sex, which is exploitation, if a UN personnel is involved in it, are criminalized. So what person is going to be keen to come forward to report to the United Nations about being involved in a criminal activity? So that's something to be very aware of. And if you're thinking perhaps of, and we're talking of course of women's rights here, but if you're thinking of a sexual exploitation or abuse of a man or a boy, in many contexts in which we work, homosexual sex is criminalized, and indeed the sanctions can be extremely heavy, even sometimes death. So why would somebody come forward? Protection concerns are also arise with regard to reprisals. More often inducements, because frequently there's a sort of quasi-relationship, and the victim concerned is being supported by the perpetrator or the perpetrator's wider community group or family, and there is a fear that they will lose that support. Stigma is real. Stigma is, we can talk about stigma and not really see it, but stigma is real, particularly if you have a child born of sexual exploitation and abuse. Abandonment is real, and then you have abandonment, and clearly within communities you can really be stigmatized and alienated. We also have an issue with regard to United Nations staff, and this is where a tension arises. United Nations staff have an obligation to report misconduct, including sexual exploitation and abuse. And that there can be a tension between that and the need to maintain the confidentiality of victims and respect their wishes. So I think I've moved. I'm a lawyer for my sins, as you all know, but I always remember what Madeleine said years ago: seeking justice, getting law. And very often women get far more law than justice. And when I speak to the people who've been subjected to these wrongs, surprise, surprise, they do not say, what really would interest me is a prosecution of X in wherever jurisdiction, or a complaint to the International Criminal Court. They say, look, I need protection, medical attention, psychological support to make me self-sufficient, and if I have a child, I need support for my child, and if possible, that child's paternity to be identified, and that father, if that father is appropriate, to take parental responsibility for the child, and the child get all of the ancillary rights relating to the nationality of the father and child support. So I'm not saying, and people often misinterpret what I say, she says law is not important. Law is very important. Accountability is extraordinarily important, but we have to look at things in a holistic way. We have made some progress, but when you're dealing with, I think there's a tendency of lumping survivors, victims into one thing. We'll have some sort of SOP or something and everything will work out well. That is not the case. It is a case-by-case examination and an approach to an individual's situation. And that can result in you really have to go to the minutiae of their situations. I do that to a certain extent, but more the field victims' rights advocates with whom I work, who work in 4 countries. They work in Central African Republic, Democratic Republic of the Congo, South Sudan, and Haiti. Haiti, because there are outstanding paternity claims, quite a few, and the other countries, because we still have quite a lot of reports, allegations of sexual exploitation and abuse. There should be more of these people on the ground, because there is nothing more empowering, apart from learning that you have rights, than having a person who is titled victims' rights advocate, survivors' rights advocate, to whom you can bring your concerns in confidentiality, and with an understanding that that person will take those concerns very seriously and work for your interests and in line with human rights principles. Thank you.
Thank you. And actually, Madeleine, I would like to follow up with you. You've had a long experience with working with various mechanisms for the protection of survivors. I was wondering, you've told us a few examples of where access mechanisms to hopefully provide access didn't function very well, for example, in the ICTY. Can you give us some examples, or at least ideas, for what more could be done?
Thank you. Just to say that I want to come in completely agreeing with what Jane just said, because I think we can't just look at justice as law. And I think what she was saying about what women who have survived the sorts of abuse that she's responsible for finding redress for are exactly those things which are fundamentally important in providing the context in which women can go forward to seek justice. They know there's going to be this supportive network, and you're not just going in to try and get one person locked up. Then it's very difficult. I mean, just to say the number of cases, we monitored many of the domestic cases in the Bosnia context of different types of violations, not just sexual violence. But so many of the people who were testifying, and of course you're testifying, you're a witness, you're just contributing to the justice process. They had different motivations for being there in any case. You know, one of them, a very pertinent witness, she wanted to find out what had happened to her husband. She wasn't there to actually was testifying to sexual violence committed against others, but that wasn't her motivation for going. She wanted to find the mortal remains of her missing husband so that he could have burial and she could have closure. And I think when you put it in those frameworks, unless you have got a system which actually recognizes what is needed to provide the support to those witnesses, then you're not going to get to the actual truth of the experience of what has actually happened, either to them or to those people they were witnessing. So I think that's hugely important to take into account, because otherwise we're just not going to be able to, I think, get the effective prosecution that we're looking for. The other thing I do think is going back to what I said earlier. I think, then just a sidestep, I don't know whether any of you have read the very, very good report that the Syria Commission of Inquiry did, called They Stole My Dignity, in which it documents the nature of the sexualized violence that took place during the course of the conflict, identifying different temporal spaces as well. So what happened over time, the nature of the violence changed, and where it was committed changed over time, and to whom it was effective, and then the gender consequences of that. And what it did was it showed very clearly, if you were in these particular detention centres, then you were going to have been subjected to sexual violence, or you would be considered to have been subjected to sexual violence if you were female, and the consequences of that were horrific. So what if, instead of insisting on individual testimony, we were able to use what I was mentioning before, is this web of documentation that we have created, by actually being able to look at patterns of violations which have taken place over time, and you can raise the bar and say, if you're in that detention facility, it is reasonably foreseeable to the extent of criminal liability, that unless certain steps were taken, then violence would have taken place. And that's the essence of some of the ICTY. And I think that is more of a way of interrogating systems of oppression rather than individual liability. And that's where we need to get to, because going after the individual violator maybe locks up that individual violator for 6 years, but it doesn't bring justice. I mean, the whole system in Bosnia is now showing that the guys who were prosecuted effectively at the ICTY, they're now coming back into Bosnia. They are back in Bosnia. Some of them are running, are mayors of different villages. So they get what they got, and the people who were testifying against them have extraordinarily difficult lives. That's not justice. So what we need to be looking at is looking at how we prosecute and get to the structures which cause the oppression in the first place. There will be individuals implicated, but it's more looking at how we remove those persons who have the control. And we've got to look at the political economy underpinning those structures as well, in order to be able to get effective prosecution and do justice to the individuals who are harmed during the course of violence, whether it be in the context of peacekeeping, whether it be in the context of actual conflict. And I think that applies equally, in fact, to non-conflict situations, because it is, as the CEDAW committee has rightly acknowledged, it's a continuum. So it's not about individualism. It is about looking at systems of oppression and actually how to give effective prosecution. We've learned enough already to know that individual accountability is insufficient.
Thank you very much for those remarks. And Antonia, I wanted to turn to you and first ask a question, and then see if you have any closing remarks. The question is, how does law choose, for example, a forum for the complaints that it is seeking to bring? And in working with victims, what are the considerations that go into that?
Thank you very much. And I'd just like to say thanks so much to Jane and Madeleine for those fantastic comments. And I was really nodding my head to those issues that you were raising. And indeed, it is about access to justice. And what do the individuals and communities want foremost, and that's the way that we then choose the forum, because I do believe that there has been an over-focus on individual criminal prosecutions, but has been mentioned by Jane and Madeleine. If you speak to the survivors, the victims, the families, ask them what they want. It might be that they want that, but often and much more frequently, they want acknowledgement of what has happened. They want to know where their loved ones are. They want compensation. They want education and medical assistance for their children. They want to rebuild their lives, and they cannot do that. And therefore, our starting point is asking them what do they want. Now, they may never get to see the inside of a formal courtroom, but what was said to me, many of those that we represent don't understand what justice is because they can't read or write. Absolutely not the case. They have an innate sense of justice. They know what they want, and we are there to help them have their voice heard. So that's our starting point. What are the options? What are the possibilities? Now, we do look where possible to take cases, if that's a kind of case they want, within a national court, but often that's not possible. I also want to say that whilst we're looking at legal redress, and we look at the whole range of it, so in this situation we filed a complaint, a communication against the government itself, because it's the government itself that must be held responsible for the actions of its state actors, but also its failure to protect its citizens. And we think that's of vital importance, and that's why also we hope that this communication will get some attention, because it's not only on the individual soldiers. And so we also, what has come out of our justice work, because justice is an entry point for healing, is that just an example in South Sudan, but also we have it in Syria, we have it with the Rohingya that we work with, that the individuals have formed groups, they have named themselves, given themselves names. For the Rohingya, they've named themselves Shanti Mahila, means peace women. And through these groups, they are empowering themselves. They come together, trying to overcome some of the stigma, some of the cultural barriers to talking about sexual violence, and really lifting their voices. And also it's assisting them to advocate for what they want. And that, as I've said, that can be a range of many things. So that's our starting point. And therefore it really varies on the forums in which we work. And it goes again to the point that Jane made, that survivors, victims are not a homogenous group, so their needs are incredibly different, and it also depends where they're currently residing and the fears that they may have for those who may have perpetrated these crimes. One moment, sorry, online screening. And I also just want to say that in terms of CEDAW, and if we go back to CEDAW, which is part of the focus of our discussion today, we've been often asked, why don't you use the inquiry procedure? You should use the inquiry procedure. Then you can protect their identities. But if we look at the inquiry procedure, it doesn't allow for requests for compensation. We have understood that. And that's not what the clients have asked for. And indeed, that's what we've been asked for by many member states. But this is not what they're asking. We're trying to respond to their needs. And if we look at CEDAW, I do think, as 40 years on, we're in this situation where I hope that CEDAW will be able to respond to the needs, to the requests of many women and girls who are subjected to conflict-related sexual violence. And in many of these situations, it's by state agents, and they're not able to come forward because they aren't able to protect identity. So, for this opportunity, that final remark.
Thank you so much, Antonia. I know we're joined by a new audience member there, but we are also slowly losing a few because I see we are encroaching upon the hour at which we should complete. Does anyone have any closing comments? I'd like to give the floor to you. I cannot see the ambassador anymore, so I'm not sure if she's still with us, but if any of the others, if Jane or Madeleine would like to say anything in closing.
I just want to thank you so much. I think it's been a very interesting discussion. It's wonderful to hear about the work of law. It's wonderful to see people again. And I think it's important. We had these events in Geneva when we were there, which were focused on connecting the dots. And I think we fail to connect the dots often. And we look at things such as sexual violence in conflict, sexual exploitation and abuse, issues relating to violence against women generally, not generally, but sexual harassment, sexual assault at the national level and so on. We look at everything we don't look at it in a joined up way. And I think this has moved us a little bit forward in terms of identifying what survivors, victims need. And I think that's a really important focus for us. We need to think, ask, and listen. So that's from me, and have a great rest of the time. And if you're going to have Thanksgiving, enjoy the bird.
Thank you very much, Jane.
Can I just jump in then, because I agree completely with Jane. I think it's been slow in happening, but I think let's try and be optimistic at the end of a very depressing year. There's not much we don't know now, and I think the interventions we've all made have shown very much the emphasis that survivors are putting on what is needed to enable them to move forward. And it's not just law, although it is, I would argue, it is law, but in other areas. So we have to look at the integration of law as convergent as to how it is better able to protect human rights and provide justice. And I think when we start removing some of those barriers and joining those dots, which we have not been able to do just yet, if we think about how we can use Security Council resolutions on women, peace and security more intelligently to inform how domestic laws should be reformed, how we approach the reform of domestic law so that it does accurately reflect all those things we've been saying today. No one said it's easy, but we have to actually, I think, have to get out of our patriarchal mindset as to how law has been devised and actually make it work for those who are seeking that justice. And I think we're getting there. Slowly, but surely we are getting there.
Fantastic. That is a wonderful note to end on. I want to thank our audience. I want to give special thanks to the Embassy of Norway, as well as to Legal Action Worldwide. And I hope everybody enjoys the rest of your afternoon. Thanks so much.
Thanks
Bye.
so much, everybody. Thank you.
Thank you.
Thank
Bye.
you.
Bye.
Bye. And Antonia. Bye.